Yesterday, the Constitutional Court ruled that the Electoral Amendment Act on the allocation of seats in the National Assembly and legislature is constitutional and does not infringe on any of the fundamental rights of the Constitution. Now, this follows a court application by the Independent Candidate Association, which argued that the Act was unconstitutional as it restricted the participation of independent candidates in their elections and their representation in the National Assembly compared to political party candidates. The court also found that the 15% signature requirement needed by independent candidates is invalid and granted an interim relief of 1,000 signatures. The Act was signed into law in April this year by President Cyril Ramaphosa, and it paved a way for independent candidates to contest the national and provincial elections. But let's get a better understanding as to what actually came out of yesterday's Constitutional Court judgment on the Electoral Amendment Act, and what does it mean for the 2024 elections. In studio with us, we've got Michael Louis. He, of course, is the chairman of the Independent Candidate Association. Michael, welcome. What a journey you've been on. Welcome to the program.
Well, thank you, Leanne. Always love being interviewed by you and Zakina. You're two special people.
So, Michael, I mean, when we look at this, obviously this wasn't exactly how you wanted it. In fact, it wasn't what you wanted. But how are you feeling this morning? I mean, when you look back and you see this journey you've traveled, you wake up this morning and you think, okay, now what? But give us your feelings now.
Well, you know, to be honest, I did wake up this morning feeling a little bit worse than yesterday for some unknown reason.
Yeah.
But then I sort of thought I had a smile on my face because exactly today, 6 years ago, and we specially planned it, I launched my first application to the Constitutional Court on the day that Madiba actually passed. Because I think he'll have a smile on his face that we're fighting for democracy. We're fighting for a new, vibrant, energetic, new fabric of leaders to come up. And so today I'm sort of thinking he would have a smile on his face because there are individuals that want to see a more direct election, people that can nominate their leaders. And that's what we need. This is a journey. The whole play about independent candidates is new, Leanne. Yeah. So as a result, we have to keep on pushing the trajectory and seeing that we've got an electoral act that is representative and accountable.
So for people that haven't necessarily been following this very closely, let's break it down in the simplest possible terms. When obviously we move forward, independent candidates move forward now with election strategies for next year, what does this ruling mean?
Well, this ruling is a little bit complicated for independent candidates because even although we do definitely accept the constitutional ruling because the apex court we really believe is independent and a great court, but the facts don't change, Leanne. The facts remain that an independent candidate has got very high thresholds to get a seat in Parliament. The facts still remain that a political party will need round about 45 to 50,000 votes to get a seat, while an independent candidate will need about 85 to 95,000 votes to get a seat. So it's really made it difficult, you know. And so our custodianship of the organisation I represent is what do we do now to still encourage independent candidates to stand? And so it's back to the drawing board for us, you know, just to see how we're going to do it.
I imagine it would be back to the drawing board because that is a very high target to achieve. Give us a practical example. I mean, talk to me about a political party that perhaps didn't even achieve that amount of votes.
Well, let me put it in context for the viewers. The last election in 2019, COPE, UDM, even Patricia de Lille of the Good Party, they all got round about 65 to 67,000 votes, and they fought it nationally. Now, independent candidates have to get, just in one province, because it's going to be regional elections, they have to get 90,000 votes. So you can imagine it's just really an impossibility. So we believe the ConCourt got it wrong. And what the effect of that is, and you're going to see it because it's going to happen, the facts are going to be is that an independent candidate with 67,000 votes will not get a seat in Parliament, while a political party with 43,000 votes will get a seat in Parliament. Those are the facts.
Yeah.
And we believe that that's unconstitutional and that will not pass constitutional muster. So I think post-election it might be back to the courts.
So obviously for these elections, that's it. It's a done deal. There is nothing more that can happen right now. But as you say, it's back to the drawing board. But that, I mean, when you look at that target, that is... One wonders what the Constitutional Court was thinking during that ruling.
Well, you know, legal cases are very legal, and they came up with two criteria of why they came to the resolve that they did. The first thing is they find it difficult that the judiciary intervenes with what Parliament decides. And so they looked at the rationality test regarding all the human rights issues, and they found that Parliament did succeed in that. But then they spoke about the overhang, which we always knew was a question, and it's complicated for the viewers about the overhang. Yes. And I'm not going into that. But the problem that they had is that we didn't come with a remedy on overhang and they couldn't rule on it. So I believe the ConCourt looked at it technically, and the facts remain it is what it is, and we just need to keep on fighting. I'm feeling bullish, Leanne. I'm really feeling bullish because I want great new leaders to stand in this country. I really want people to really nominate the best leaders that they can touch and feel and that represent their views. And so we are going to go back to the drawing board to see what we can do. We're not giving up. It's been a 6-year journey. It's another long journey, but that's what democracy is about.
Yeah, it is. It is. It's about fighting for what you believe in, and this is what you really do believe in. What about parties that are not represented currently in Parliament? And we've seen a rise of so many new parties. I mean, we can talk to Action SA for one. We can talk to Rise Mzansi. There's so many of them. What does this mean for them?
Well, look, the sad part about the judgment was that the Rise Mzansi or one of the civil society organizations went in with an application also to come in as amicus curiae. And the court resolved that the facts weren't before the court, and as a result, they said only independents need to get 1,000 votes, but new political parties that are not on the political landscape still need to get 15% of the quota. So they didn't succeed. I've sort of heard rumblings this morning that there are two political parties that are going to go and challenge the ruling to say that they also need only 1,000 signatures and not 15,000 signatures. Yeah. So I think the ConCourt is going to be busy, but it's part of our vibrant democracy, and so we just need to do what we must do.
Yeah, I mean, it is a very, very difficult situation for new entrants to come in, and people are screaming for new. They are. The people of South Africa want new, fresh, vibrant politics, not the same old, but it seems like, you know, we are stuck in the same old. I mean, these were decisions that were taken a very, very long time ago, and things have evolved and changed, and yet there's a fight to keep it to the old. And that's, I think, what's happening here, and perhaps that needs to change. I mean, you had asked the court to allow independent candidates to contest 350 out of the 400 National Assembly seats. That was also declined. The 200 seat split remains. I know it's a tough thing to explain for us laymen that were not in the court, but perhaps maybe you can go ahead and explain.
Well, I think the big thing is why 350-50?
Yeah.
Because we had two actuaries that did the sums. And if it's 350-50, then what it does is that independent candidates only need to get 45,000 seats, 45,000 votes, the same as political parties, because that's how the division happens, and that's how we got to the 350-50. And so that was the rationale. So I want to make two statements, Leanne, that might be interesting. The first thing is that there is a scenario that a small party or one person cannot make a difference. I totally reject that. I am a real example of how one person can make a difference. And we need to change the public's mind. You mustn't vote against something. You must vote for something. Vote for an individual or a small party, because we're not against political parties. Political parties are there to stay, and they play a very important function. But let's take the example of Thuli Madonsela. She's one person. Don't you think we must make it easy for her to stand up and represent us? Isn't she an individual that we're wanting to see in Parliament? So as a result, I think that there's a lot there. The second thing I'm wanting to say to you is that independent candidates don't qualify for 200 compensatory seats.
Yes, that's what I wanted to speak to now.
So say now, for instance, in a bizarre situation that the independent candidates that stand get all 200 seats in Parliament. What happens because they don't qualify for the 200 seats? What happens in a scenario like that? You'll have no proportional seats. You'll only have a Parliament of 200 seats. So we believe there's a lot that we need to grapple with, a lot that the courts need to grapple with, and that's why the electoral panel that the minister is going to announce soon, it's going to have another 2 years to revamp this Electoral Act. What happened with this historic judgment, it sort of puts stakes in the ground.
Yeah.
How do you see proportional representation? How do you see compensatory seats? What is right? What is wrong? What is rational? And so we just have to walk this path.
Indeed. But you said this in your opening answer, and one of the big things is this is a ruling that very much so may scare independent candidates. I mean, if I, Leanne Manus, decide I want to go, let's talk about this as a plain example. So I need to get 1,000 signatures, okay, which is the one victory which we got, which we know that was a good victory that came out yesterday. So I'm sure I could gather 1,000 signatures.
You will be able
but
to.
I then have to pay the costs. What costs would I have to pay in order to run?
Well, the IAC has nominated, and it's not so much for independent candidates. They have been considering that political parties must pay more. So it's anything from 50 to 100,000.
So I would be the same. I would be liable for the same amount as a party.
No. The political
Different.
parties pay more than an independent
And then
candidate.
I'd get onto a ballot sheet, and then I'd have to get...
Then you're going to have to get about 90,000 votes to get in.
And now this is just for one region. I mean, I may not even be... I can't afford to run nationally, but this is for one region. And this is where the problem comes in. This will scare independent candidates away. Do you think this is going to see the numbers drop substantially in terms of people that have said, I'm going to throw my hat in, and now they saw this and they're thinking, there's no chance?
The sad part is I don't think the mantra and the test for has independent candidates got a place in our society going to really succeed, because already I know that there's going to be a lot of independent candidates that rather will fulfill and form part of civil organizations or movements or then jump to go to political parties, which is really sad, because I really believe that there's a place for independent candidates. But maybe we come up with some alternative that will encourage and will support independent candidates to apply and to be able to get into the compensatory seats.
Yeah. I mean, I know you are part of the justice system. It's what you do. Obviously, we talk about it as being very independent, but there is a school of thought out there saying that this Electoral Amendment Act will not deliver equitable results or equitable electoral system, and that's what the worry is. Do you agree with the school of thought?
Well, I think the electoral system from day one we've rejected, because we don't believe the system that the minister devised in the Electoral Act was right for an independent candidate to compete with a political party. The only way, Leanne, that we've been promoting and that will work is a constituency-based system where individuals in their constituency can nominate their leaders. That's what we've been promoting from day one. The Parliament passed an act and we had to play by the rules. But we will be pushing in the next term, definitely for a constituency-based system. This is what our country needs. It's the only way we're going to succeed in a vibrant, more inclusive and accountable democracy.
Well, I know we haven't heard the end of you. I know this is just the beginning. 6 years down the line, this is where you are. I look forward to seeing what happens in another 6 years' time when the next elections come around. Michael Louis, chairman of the Independent Candidate Association, talking to us here about yesterday's landmark Constitutional Court judgment on the Electoral Amendment Act. Thanks very much, Michael, again for being with us.